Lords, can I check what you've received and what you've read? There has been a very late flurry of documents.
Yes, well, we've received the judgment of Mr. Halpin recently. We've received your both sides supplementary skeletons relating to that judgment. We have the core bundle, which has got the original skeletons plus the judge's judgment, which we've read. And we've got a bundle of authorities, and we have read Hoffman LaRoche, Kirklees, FSA, Park Hill, whatever it's called, and Abbey Forwarding.
Well, I'm very grateful. That will, I think, speed up my review of the authorities, which I'll be covering during my submissions.
Yes, and really the question is who's right, Mr. William Blackburn or Mr. Justice David Richards?
Well, look, I think that's probably a fair summary of the question for this court. The reason HMRC is here, of course, is that since those decisions, there have been many applications made by HMRC to appoint provisional liquidators, not in ordinary cases, but where there is a suspicion of tax fraud. And those are necessarily ex parte applications. HMRC has a duty of full and frank disclosure, and so each time HMRC comes before the court, it has to take the court through all of the conflicting authorities and leave it to the judge to decide what the appropriate way to proceed is in relation to the cross-undertaking and damages. That may well be the approach HMRC has to take going forward, depending on the view your lordships take. But HMRC would be greatly aided by guidance from this court, saying that is HMRC in the public enforcement, the law enforcement category, and then the court has discretion, or is it simply not, which is, I think, the view taken by David Richards in the Abbey Forwarding case, and for the reasons in the judge's note of his judgment, which I'll take you to, that seems to be particularly persuasive to him.
Yes.
He said HMRC is simply a creditor.
Yes, well, that was the view Mr. Justice David Richards took, that you were exercising remedies which are available to any creditor.
Indeed. So it may help to run through the background a little bit, because the position at the time the appeal was brought and the position now is rather different.
Yeah.
And you may see a marked distinction between how the case is put in the appeal skeleton, how it appeared in the original judge's judgment, and how Sir David Halpin KC, what his actual findings were, and therefore what the supplemental skeletons say on both sides. As it was originally put before the judge, this was a tax fraud, and what HMRC had done was it had conducted an investigation into this company behind the scenes. That investigation had involved obtaining orders from the tax tribunal ex parte to get sight of the company's bank statements, and it had also involved inquiries being made with the company's customers. And my lord, you may have gathered from the material that the business of this company is an umbrella company. It's quite an unusual thing, although now quite commonplace. To put it in neutral terms, it has workers, it has contracts with workers. HMRC says those workers are its employees in this case, but Mr. Halpin disagreed with us. It has contracts with workers. It also has contracts with agencies, recruitment agencies. And those agencies find work for the workers from, in particular, the NHS. And what the umbrella company does is it allows the agency to push off the responsibility for managing the payroll functions to another company. And one of the benefits of that is that the agency then doesn't have to consider whether it's the employer and responsible to account to HMRC for payroll taxes, national insurance, pay as you earn, and that sort of thing. That becomes the responsibility of the umbrella company. What HMRC thought was that this umbrella company was employing all of the workers, and the evidence that HMRC had obtained from the agencies supported that view at the time. The evidence was, there were 4 forms of evidence, and in Mr. Halpin's judgment at page 200 in the supplemental bundle, he runs through what that evidence was. There were questionnaires which the company filled in with the agencies, which said we're going to employ everyone, they're all going to be employed, not workers, not self-employed. There were pay slips which the company created, which made it look as if deductions had been made for national insurance contributions and PAYE on the earnings of workers. There were contracts with the companies, between the company and the agencies, all of which said we will only provide workers who are employees, and there were warranties and indemnities against any tax consequences that turned out to be wrong. And then HMRC also made inquiries with certain agencies, and they all responded to say, as far as we know, this company is deducting PAYE and national insurance contributions.
But where does this take you? I mean, Mr. Gasztowicz was satisfied on the evidence that you presented to him that you were entitled to the appointment of a provisional liquidator. The question was, what if you turn out to be wrong? Should you give a cross-undertaking and damages?
Well, yes, it's as simple as that. But I refer to these points, I think, to say, why is it that we're here in a situation where the provisional liquidators have been discharged, subject to a short stay pending any further application for leave to appeal to this court? Why is HMRC here? How has the position changed? Should the court have regard to the fact that HMRC has actually lost? So if one's looking at whether, under the test in the...
Well, wait a minute, you're here because Mr. Gasztowicz refused to give you the appointment with the provisional liquidator without the cross-undertaking, and you gave it, and you say you shouldn't have been asked to do that.
Yes, well, in many ways, then, I don't need to press the point. In some ways, I'm addressing a criticism that might otherwise be levied against HMRC, that we've lost. This court can now see that it was unlikely that a winding award would be made.
Well, there was always going to be the possibility that you lost. Indeed. When the provisional liquidator was appointed.
Yes.
Because that's in the nature of a without notice one-sided hearing.
Lord, that is right. And what HMRC says in its supplemental skeleton is that the fact that we've now lost shouldn't make a difference. There will always be cases in which that risk will eventuate. It's in the nature of not having cross-undertaking and damages that there will be losses which can't be compensated for if there's no cross-undertaking and damages. So, with the greatest respect to the company in this case, not wishing to make an example of it, we say, we're sorry. It's simply not right to have given this cross-undertaking, and we should be free from it now.
Yeah.
Albeit that we can see that that's going to cause potential loss to the company. So, Lord, perhaps we should go straight in then to the judgment. We can see what the judge said.
Yeah. Can I just get the statutory framework? As I understand it, the liability to pay arises under regulation, under Schedule 4, paragraph 10, something like that. It's the regulation, scheduled to the regulations.
Yes.
And under regulation, I think it's 16, unpaid contributions are recoverable in the same way as tax. I think that's right.
My Lord, yes, we have, Mr. Elliott is actually a tax barrister, and so if we, between us, go wrong at any point, he will jump up and correct us.
And I think, if I'm right so far, that brings in the powers which HMRC have under the Taxes Management Act, which include the right to sue in the county court or the High Court, and the right to distrain, or I think it's now taking control of goods under the Tribunals and Courts Enforcement Act. Plus, of course, the right that any creditor has to present a winding up petition.
Well, yes. The way it was presented in front of Judge Gasztowicz, was that HMRC didn't, in fact, need to make a decision in order for this tax to become due. And we referred to paragraph 10 of Schedule 4, and we took him to that. And my learned friend in the supplemental skeleton for this court makes a complaint that he's made on a number of occasions that transcript, not the transcript, the note of the hearing, the ex parte hearing, recorded me saying that all the tax authorities had been taken out of the bundle. What actually happened was my clerks had included the whole of Schedule 4, which is hundreds of pages, which made the already very long authorities bundle unwieldy. So we took out everything apart from paragraph 10, which was the paragraph we were relying upon. And before the judge, we said, we don't need to make a decision, to provide a decision notice under Section 8. If we do so, it simply tells you why you're liable. But in fact, if you fail to make deductions from the emoluments of employees, it doesn't mean you're not liable to pay them across. Yeah. It simply arises under the statute. And so that was the position we took there. At the petition hearing, we didn't ask the court to consider that point, it being unnecessary by that stage, because we had issued the Section 8 decision notices.
Section 8 of what? You refer to Section 8 in the evidence, but you don't tell me what. Section 8 of what?
Well, I'll have to get the wording exactly right, which means I will have to turn my back, I'm afraid. Lord, I can find the decision notices, which are in the core bundle, and they will tell me. They are, it's page 73 in the core bundle, tab 7. Yeah. And the reason I can't remember it is that...
Social Security transfer... I see.
Yes. So, my Lord, I hope I could be forgiven for not having that on the tip of my tongue. The reason HMRC didn't push this point in the petition hearing was that whether HMRC was a contingent or prospective creditor or an actual creditor at the date on which it presented the petition didn't actually matter. Because by the time the petition came to be heard, it was an actual creditor.
Yeah.
The Section 8 notices had been filed, if those were required. And so the point simply didn't arise for decision. My Lord, whilst we're in the core bundle, that's where we find the judge's judgment. And it starts, it's behind tab 5. It starts on page 44.
Yeah.
Lord, you've already grasped that the judge was satisfied that it was appropriate in all the circumstances to appoint a liquidator. And you'll see at paragraph 35 of the judgment, page 51, that he was satisfied that there was compelling evidence of under-declaration.
Yeah.
So on the evidence he was shown, which subsequently turned out may not quite be right, because these payslips were in fact false. On the evidence he was shown, he was satisfied that the company was not paying what it ought to have been paying. The passage on the cross-undertaking and damages starts at page 55, paragraph 62.
Yes.
And, my Lord, there's quite a long discussion here. It was fully argued before the judge. I should say, in fairness to the judge, this is simply a note he prepared from his own notes of the judgment. My memory of the way he delivered his judgment was that it was smooth and coherent and exactly...
It wasn't transcribed?
It wasn't transcribed. The audio recording was too poor to allow it to be transcribed, so he had to go back to his notes. HMRC had taken its own note, which we sent to the judge. He went back to his notes, he used those notes and HMRC's notes and prepared this document. So it is perhaps not as fluid, not as clear as it appeared to be when HMRC heard the judgment at the when it was delivered. The crux of his decision is at page 65, paragraphs 99 to 103.
Yes.
Although I could read that out, but it may simply be easier to read itself.
Yeah. And it's really 103 when it comes to its conclusion.
Indeed. So he says it's a debt. Because you're a creditor petitioning for a debt, it's not a law enforcement at all. It's a recovery of a debt. And that chimes with the reasoning of David Richards in the Abbey Fording case, which you'll have seen. He then goes on to draw an analogy, which is one that was discussed in the argument about speeding. Enforcing the law, stopping people speeding, is law enforcement. There may be fines if you speed, and when you recover those fines, the position may be different. And what he said is for HMRC, you're just recovering debts. That's all you're really doing. He considered, before I finish with his judgment, he did consider paragraph 111, page 68, a submission made to him about deterrence. And my Lord, this is one of the points on which HMRC appeals this decision. We think he was wrong about this. But paragraph 101 records the submission that was made to him. So when HMRC has to give a cross-undertaking damages, it can't simply offer as many cross-undertakings and damages as it likes. There are budgetary consequences behind the scenes, whereby money has to be set aside to cover the possibility that the cross-undertaking may be called upon, as a matter of government accounting and good management of public funds. The risk otherwise is that HMRC could give as many cross-undertakings as it liked, and the consequences at an extreme end of the spectrum could be disastrous. So there are budgetary constraints. Those were referred to, and the judge downplayed them. He took the view that government...
Is that in the evidence somewhere?
It's paragraph 111.
It's paragraph 111. Yes. My Lord, it's not in the evidence anywhere. It was simply a submission justifying the HMRC's position on the cross-undertaking, that there is a deterrent effect.
Yeah. And if there were to be a limit, what limit?
Well, my Lord, the position is one sometimes sees judges who treat HMRC almost like a liquidator. They get in all of the tax revenues and they take the first slice as their expenses and they distribute it to all the departments, almost in the position of unsecured creditors. That's not the way it works. HMRC is a department like any other. It doesn't get first dibs on the tax money. It doesn't have a call on the vast sums that are raised from taxpayers generally. It has a departmental budget like any other department. And Laws, you may recall in the Kirklees case, that there was a particular concern, sorry, not the Kirklees case, it's Lord Cross in the Hoffman-La Roche decision, a concern about the deterrent effect on public bodies in enforcing the law if they're going to be liable to pay damages if it turns out they're wrong. There is a departmental budget which is used to stand behind these sort of applications. And HMRC has to consider very carefully whether to proceed or not.
Yeah.
And there is a deterrent effect. And the unfortunate problem is that the deterrent effect is most acute in the cases which call most for a provisional liquidator. Because the larger the tax fraud that the company appears to be carrying out, if HMRC is wrong, the larger its business, its legitimate business, it turns out that the business is legitimate. And if that business comes to be destroyed.
I'm right, am I, in thinking that in the past, HMRC did give cross-undertakings. So back, say, in the days of rife MTIC fraud, where HMRC obtained many appointments of provisional liquidators, it gave cross-undertakings and it backed the provisional liquidators in their applications for freezing orders.
Yes.
So they lived with that.
Yes, my Lord, it has happened historically. I think, I don't know whether there's been a change of policy behind the scenes, but there are at least these decisions that need to be reconciled. In this case, of course, HMRC didn't back the provisional liquidators to give an unlimited cross-undertaking. And the provisional liquidators sought a freezing order to follow on after they were appointed by Judge Gasztowicz. Because they couldn't give an unlimited cross-undertaking, the judge didn't make freezing orders.
Yeah. Well, can I ask you again, if there were to be a monetary limit, what is it?
Well,
Well, we can't just pick a figure out of the air.
No.
There has to be some evidence about this, doesn't there?
well, there would have to be some evidence. It may be a case that depends on the circumstances of the case. So it could be, for example, that HMRC offers a cross-undertaking that's capped. One of the possibilities in this case was a capped cross-undertaking.
Where did the HMRC budget come from? Does it come from the Treasury ultimately?
Lord, I think it does. Yes.
So why isn't this a matter for you in the Treasury? The HMRC, I assume, a statutory body, but if they're getting their funding, if they're handing over the money to the Treasury, why isn't any concern dealt with by way of an arrangement between you and the Treasury? Why must the individual company bear the risk? It's the company versus the state, really, not the company versus HMRC.
Well, my lord, that's right as far as it goes, but HMRC is just another government department, and one could say the same about any law enforcement action, that any emanation.
If it's a law enforcement action, yes.
Indeed, it sort of begs the question in some ways. But if one assumes that public funds are finite, public funds for enforcement work are finite, then every time the court requires unlimited cross-undertaking and damages from HMRC, that uses up a slice of the finite funds.
Well, I can see that may be an argument for not requiring the cross-undertaking at all, but I'm sorry to repeat my question. If there were to be a capped cross-undertaking, what is the cap?
Well, Lord,
How can we, or how could the judge have decided what the cap should be if it was an appropriate thing to do?
Well, the way HMRC approaches this is to estimate what the likely loss is. And one way it does that, it looks at the shareholders' funds in the company's most recent accounts to give a pre-estimate for what the company is actually worth. One of the difficulties with this company is its accounts, well, at least at first the ex parte hearing, were identified as not really tallying with what its financial position appeared to be. And that remains the case. The Provisional Liquidators had serious concerns about the way this company has been operating. They filed a note for the hand-down hearing last week, which identified that the individuals behind the company had a lot more out of it than the accounts would reveal. But it's not a point on the evidence that we can really go to. But in this case, the company's accounts show a relatively small net asset position. And what HMRC would say is, well, that's what we should compensate the company for if it turns out we're wrong, because that's what the company is saying it's worth in some respects.
I understand that.
And so that's where the cap is. And if that were the cap that were applied generally, or in this particular case, at least that is a relatively low, visible, certain figure. It doesn't have the danger of an entirely uncapped, at-large cross-undertaking, which may cause very substantial losses to the department if the cross-undertaking is called upon.
Yes, I suppose it would be what? Value of the company plus whatever the provisional liquidator charges?
Well, Lord, yes, and we have some evidence of that in this case, because the Provisional Liquidators filed material last week. One of the issues for David Halpern on the hand-down hearing was whether HMRC should simply be made directly liable for all the costs, remuneration and expenses of the Provisional Liquidator. And the position HMRC took, and the decision the judge reached, was that HMRC isn't directly liable other than via the cross-undertaking damages. So there are two ways out for HMRC. There's this hearing, we're freed from the cross-undertaking, we won't have to pay the remuneration and so on. Alternatively, we'll say we'll await the outcome of the tax tribunal hearing. There will be a tax tribunal challenge, as HMRC understands it, to its decision notices. There, the burden will lie squarely on the taxpayer company to show that HMRC is wrong.
Yeah.
It will have to prove the complicity of the agencies in what was going on, and so on. And HMRC says, well, we'll follow that with interest, I think. We won't know if the company's actually suffered any loss until those proceedings are concluded. Because on HMRC's case, this company was, its business was improper.
If the consequence is you can't get a provisional liquidator appointed because you're too worried about the cross-undertaking, I'm not a tax lawyer. Wouldn't you just then sue for debt, or are you just worried that it'll all be folded up and hidden away? What's the problem with going for other remedies?
Well, the problem is, and this picks up a point in the authority about whether HMRC has a choice. So David Richards formed the view that HMRC didn't just have to go after companies by provisional liquidation applications. They could sue in the county court, they could issue assessments, they could recover the debts in other ways. They could simply present a petition if they wanted to recover the tax through the insolvency process. They don't have to go a further step and appoint provisional liquidators. What HMRC says in its skeleton for this appeal is that is an unrealistic view. It doesn't reflect how HMRC ought responsibly to act when it's faced with a tax fraud.
But why? That's to say you don't agree. I don't understand why you don't agree is my problem.
The reason we don't agree is that if you let fraudsters know that you're coming after them, the first thing they're going to do is take whatever money they can.
So that's your fear, that if it's a fraud, so this is just concerned with those cases where there's a debt and the debt arises in the context of fraud. And because you suspect fraud, you suspect that they'll destroy the documents or whatever, move the assets or whatever.
Indeed. So HMRC doesn't go for provisional liquidation appointments as a matter of course. That is, I don't think I'm giving evidence when I say that. It only does it in cases where it thinks it's appropriate and necessary. And those are typically fraud cases.
But if HMRC are right, then there's no problem. The problem arises if HMRC are wrong, and there is no fraud.
Well, that is right, and that's exactly why we're here.
Yeah.
We say that HMRC should be able to go after suspected fraud. There will be necessarily anxious scrutiny of any application on an ex parte basis for the appointment of provisional liquidators where, in a case of a suspected fraud. Of course there will be. And it may be that the absence of a cross-undertaking in damages makes a real difference to whether the court will take the step of appointing provisional liquidators. It's all part of the same exercise. And if one ignores that we think the judge is wrong in how he approached this case, he was clearly not willing to appoint the provisional liquidators without an unlimited cross-undertaking in damages, so he was at least seeing the two things as being related. We say he formed the wrong view about that, and if he formed the right view, he would have been satisfied and wouldn't have required unlimited cross-undertaking damages. HMRC doesn't have a choice when it goes after fraudsters. If it lets them know...
Suspected fraudsters.
Well, suspected, indeed.
Some of them may, be innocent.
Some of them may be innocent, and there is at least a bona fide dispute on substantial grounds about whether this company is an innocent company.
Yep.
HMRC accepts that. That's the decision of Judge Halpern. In terms of how HMRC approaches this, though, firstly, we can't tip off fraudsters, and secondly, it's right to do it in a two-step process, whereby we go for provisional liquidation first, and the provisional liquidator then goes after the assets, in the wide sense of including books and records and so on, by way of a freezing order. And the authority for that proposition is the Eggleton case, which erroneously in my appeal skeleton I put down as a decision of Mr. Justice Etherton, but it was Mr. Justice Briggs. So in the Eggleton case, which is at page 166 of the authority bundle, the relevant passage that starts at page 166 of the authority bundle, page 57 of this report, paragraph 48. The Lord's paragraphs 48 to 51 explain the reasons why Mr. Justice Briggs deprecated HMRC's approach that it took in that case, the Eggleton case, of itself seeking a freezing order in connection with a winding up petition. Lord, it's pages 166 and 167.
I see that. What does it add?
What it adds is that HMRC couldn't, for example, simply seek a freezing order.
Well, you could. You could bring a debt claim and seek a freezing order.
We could, but the Eggleton case says we shouldn't.
Well, it doesn't, does it?
Well, in the
It
context
says
of-
that if you're bringing a petition, you can't ask for a freezing order. But it doesn't stop you bringing a debt claim and asking for a freezing order. And indeed, if you were bringing a debt claim, you wouldn't have to worry so much about whether the debt could be disputed. That would be subject to determination.
My Lord, that may well be right, and we'd then find ourselves being able to rely on the decision of Mr. Salzedo KC in the Rhino television case, where he said that he disagreed with David Richards in the Abbey Forwarding case insofar as it covers both provisional liquidations and freezing orders.
I don't assume that you wouldn't have to give the cross-undertaking on the freezing order. Maybe you would, but I'm not quite sure where Eggleton takes you on this. I mean, I follow that if you petition, then the right course is not yourselves to ask for the freezing order, you need the PL to ask for the freezing order.
Well, it may be that there is an alternative course open to HMRC to seek a freezing order in those circumstances. But there is another aspect, I think, to whether HMRC has a choice. So what we've seen is that HMRC going after suspected fraudsters can't tip them off. If it is bringing a petition, it shouldn't do what was deprecated in Eggleton. It should seek a provisional liquidator.
I mean, one of the reasons that Mr. Justice Briggs gave in Eggleton was that if the PL obtained the freezing order, the court, as a matter of routine, extracts an undertaking to issue a claim form and so forth. So,
Well, my Lord, that's about mechanics and supervision of the proceedings once they start. The danger Mr. Justice Briggs was particularly exercised about was that a petitioner comes along, obtains a freezing order, and then disappears.
yeah.
They fall out of the picture because their involvement is really just to start the proceedings, whereas a provisional liquidator potentially stands for the duration, and the enforcement work that the liquidator can do once appointed can seamlessly flow from the work done by the provisional liquidator.
Because, of course, it's then a claim by the company.
Exactly.
Yeah.
So the creditor falls away, and it's not right to have given the creditor, whose interests may not entirely align with the class, certainly not with the interests of the company, the power to jump in and seek a freezing order in the first place.
Yes.
So, my Lord, the third aspect of choice is about HMRC's position as an involuntary creditor. Lord, this isn't perhaps the strongest point, but it is, I'm afraid, an obvious one. HMRC doesn't choose to become a creditor of companies like PPS. Statute provides that certain activities will give rise to tax consequences. And so, unlike a normal creditor, who can choose whether or not to contract with a company, can choose how to sue, choose how to pursue a debt, what accommodations can be made, and so on, HMRC isn't in that position. Its starting point is that the taxes simply arises, it gets handed with the situation, and told to do its best. Lord, come to, I think, I touched on fraud as part of the question whether HMRC has a choice in how to proceed. I think that the fraud law enforcement exception requires a bit more elucidation. And I'd repeat what was said in the skeleton, I think, in the following words, which is that enforcement of tax law against those who appear to seek to break it looks more like law enforcement than the routine collection of tax. HMRC obviously presents a lot of winding up petitions, and it does so as a creditor. It seeks a winding up or a bankruptcy order on the grounds of inability to pay debts, tax debts. I leave to one side for now HMRC's novel ability to petition in the public interest against promoters of tax avoidance schemes. The first such petition is about to come before the courts.
I didn't know that power had been granted. That's in recent legislation.
Yes, Mr. Elliott and I are working together on that one.
Where do we find that power?
That's Section 85 of the Finance Act 2022. But that doesn't apply to tax avoidance generally. It applies simply to promoters of tax avoidance schemes. And I use that language as a summary, I think, of rather a complex provision. It's about promoters of relevant arrangements, which are then defined in a whole series.
And that is, so to speak, a freestanding power. It doesn't amend the Insolvency Act.
No. So it's a freestanding power. It's a public interest. It's the rules for public interest petitions under 124A are applied to petitions like that. And the first such case is coming before the courts. The petition has been presented. It appears to be contested in vigorous terms, and a judicial review has been, application has been made.
And what's the remedy you get? What does Section 85 allow you to do? It grants the power to do what?
A power to petition to wind up a company in the public
There's a
interest.
power to wind up or petition to
Yes.
wind up. Them.
So one of the points, my lord, that you noted in your decision in Rochdale Drinks is that sometimes HMRC gets on its high horse and tends in its creditors' petitions to be saying we're acting in the public interest.
Yeah. Yes, and the point that I was making was it's only the Secretary of State who can do that.
Exactly.
But
So
now you say, well, there is this power, this new power, which I'm afraid I didn't know about, I must say, to present a public interest petition in defined circumstances.
there is. It wouldn't apply for this company.
Yeah.
But the aim of this power is to bring the company to an end,
It is.
to stop it existing.
It is, yes. I mean, there is no recovery of a debt. That's,
It's
that's
a
not an
statutory
answer.
execution.
Indeed. But the company can provide undertakings in the Amway decision under the public interest jurisdiction. If the company provides undertakings that are satisfactory to HMRC not to conduct its business in a certain improper way, then perhaps those will be accepted by HMRC or accepted by the court, and the petition will be dismissed. In an ordinary case, it's designed to kill the company.
Exactly, yes. It's the guillotine.
Indeed. And the reality is that a creditor's petition presented by HMRC against a company like this is designed to have a similar effect. The tax liabilities that HMRC perceived this company to have accrued were fatal to it. It had no possible way of paying even the employer's national insurance contributions that HMRC based its petition on.
I mean, I follow that this is part of the thinking, but that's not the basis of your right to petition, which is debt. And indeed, looking at the grounds on which you ask for the PL, they're still debt related. The assets might be dissipated, the books and records might be gone, so we'll find it hard to find out what was going on. They're not based on the public interest.
Well, that's right. In some respects, HMRC is simply seeking its money back. But the court shouldn't close its eyes to the reality that there is a public interest in the company, in HMRC, stopping tax fraudsters, which sits above simply getting the money back.
That may be a consequence of making people who are fraudsters pay money, but you're not actually seeking a criminal sanction or an injunction or anything else. That seems to be the reason why, in this case, you suspected that these people weren't paying the tax that was due. It could be negligence, it could just be they haven't got around to it. In each case, the legal responsibility is to pay the tax that's due, isn't it?
Well, that's right. There is only a legal... the only obligation on the company is to pay the
Pay
right
the tax, yes.
But when HMRC goes after someone who is suspected of having the language used in witness statements in support of the provisional liquidation application, which is not in bundle, but summarised in my skeleton first instance, it was considered to be a sustained attack on the tax system. The court shouldn't close its eyes to what, although there is a debt at its heart, the wider picture. The wider picture is that these people, the suspicion is that the company has not only not been paying what it ought to be paying, but it's been set up in such a way as to exploit the tax system on which honest taxpayers are paying the appropriate tax. And there's a danger of HMRC getting on its high horse here, but I think there is a public interest element in recovering tax debts from tax fraudsters, and it goes beyond simply getting the money back.
Yeah. Yes.
So, my lord, that in summary is what HMRC says. When we go after tax fraudsters or suspected tax fraudsters, we shouldn't be required, as a matter of course, to give a cross-undertaking damages. It remains a matter for the court's discretion, but it should at least consider that it's a law enforcement case, and therefore capable of being exempted from the normal position, whereby the price of your relief is the cross-undertaking and damages.
But I mean, a first instance court hearing a without notice application needs to know, doesn't it, what's the starting point?
It does.
Can't simply say, well, it's all a question of discretion for the court. So, I mean, are you saying that the starting point is that where HMRC alleges that there has been tax fraud, then even though in form its petition is based on debt, there is a sufficient public interest element so as to make the starting point that no cross-undertaking should be given?
My lord, yes, that is a summary of exactly what HMRC says this court should find. Because if HMRC is left with the starting point that applies in normal cases, it will always have to give a cross-undertaking. There's no doubt that HMRC can afford it. None of those cases will assist it.
Yeah.
So, my lord, I haven't taken you to the decisions. I think you've read most of the relevant ones. Ultimately, it's a decision between whether you prefer Sir William Blackburn's decision in Parkwell or Mr. Justice David Richards' as then was in Abbey Fording. HMRC says Parkwell was right. Mr. Justice David Richards was overswayed by the substance, the form of the proceeding, not the substance. He said because it's debt recovery, it's a creditor's petition, it can only ever be the normal position, and that wasn't right. Lord, there is one further authority which I don't know if it's one that you've had a look at in your pre-reading, which was the Anchor Foods case. Decision Mr. Justice Newberg.
Yes. That was approved in the FSA.
My lord, it was. And this is one to Anchor Foods is at Authorities Bundle page 149 behind tab 3. 149 is the relevant passage. So page 1150 of the report, starting at paragraph 9, there's a discussion which runs down to the paragraph F on 1151, and the conclusion is over the page on 1152 at B to D. And my Lord, that's, although the decision is approved in the FSA case, this passage is relevant and I'd like the Lordships to take it into account.
Yeah.
And my Lords, I should say, of course, picking up a point from learned friends making their supplemental skeleton, this is, of course, a decision that went against HMRC.
Yes.
It was a very unusual situation where HMRC was seeking an injunction to prevent what appeared to be a bona fide transfer of Anchor Foods, the butter company's business, to a new co, leaving behind its debt to HMRC. HMRC sought an injunction to prevent that happening. There had been accountancy evidence filed on both sides, with one side saying it was a perfectly proper transfer and the other one saying it was a massive undervalue. The court considered it was a very unusual case. HMRC's objections were raised relatively late. There was sufficient evidence from independent valuers that HMRC ought to give a cross-undertaking damages. Because it wasn't clearly a fraud case. That's I think the difference there. So HMRC had to give a cross-undertaking damages in that case. But what Mr. Justice Neuberger said is that there is a spectrum from the law enforcement end, and at the other end simply enforcing a contract, proprietary rights. And HMRC sits significantly closer to the law enforcement end of the spectrum, and that reflects, I think, an appreciation for what's really going on with the collection of tax. HMRC doesn't push it quite as far, I think, as Mr. Justice Neuberger went. HMRC doesn't say that it's always subject to the public interest exception, but certainly it is when it's trying to pursue suspected tax fraud. So, my Lord, I draw that authority to your attention in addition. My Lords, I don't think there are any other authorities that I need to take you to that we haven't already pre-read in pre-reading. Unless I can assist you further, unless I have instructions behind me, I'm not sure what else HMRC needs to say on this appeal.
Right. That's very economical, Mr. Parfit. We'll just rise for a couple of minutes.
The live streaming will remain on because it's only for.
You want to go?
Can we go outside for a second? I don't know how long the judges have, but I presume so.
Do you want to go?
When they're ready, I'll come look for you.
I just think I don't know. Oh yes, sorry. Make sure we get that. Yeah, sure. Yeah, could you do that? Sorry.
No, that's.
Yeah. Say to me, what I know exactly. I think what's your response? I think it becomes self-certification. How is a judge to know? To judge for the extent of the reasonableness of HMRC's beliefs to the hearing on side, and whether there's been frank disclosure. They're not in a position to do that, so it becomes self-certification. Also, it's accepted. You've got order to yeah. I think so. I do think, in the balance, I think section 2 is in our favour. It is in our favour, for the reason they've said. That's your public interest. Yeah. You've been given specific. Yeah. At this, our big point is, at this stage, if the
them to change the position. If they want the revenue to be special class, then they need to give them wider public interest powers, or they need to pass some sort of acts. Of course, this all started with the 1947 Act. Didn't it? That's what removed their immunity, and then the courts have carried on quite happily. So it's for Parliament at this stage. There's the big points. Goodness, the amount of praise there was there.
You think so?
Yeah. The other big point is there is where an example of a case where revenue were actually deterred from doing so all this giving evidence from submissions, but there is zero evidence of deterrence, and that's a huge point I think we need to start with. They can talk about it being deterrent, but there's just no he's admitted it. He admitted it. There's no evidence. There is not a single case they can point to. The revenue saying, "Oh, we would have got it." He didn't say, "No, the PMs were deterred." Why didn't the revenue give an undertaking to support the PMs? They could have done. I mean, it doesn't matter. But the point is, of course, if they'd got a freezing injunction, well, they couldn't have gone against the individuals. I suppose that's for the PMs, but they could have underwritten that. It's their own problem.
I see what you mean.
Other benefits to do. Some other points. The capping. Just to be clear, is it value of the company or is it net asset position? Because it got a bit confusing. Those are two very different positions. Because net assets of this company are low, but obviously profits. I mean, value of the company is measured via profits. I mean, I don't think that would be the end of the world. He accepted there may be an alternative here. Parfit accepted it's a discretion. So that goes out. I do think no matter what they say, please take them
to 69.
To 69 and say, just to be clear, we do think this is an important point. But actually, the judge's actual decision, everything that follows is actually irrelevant. Submission of insurance.
Council just popped out. Let me get rid of it.
You're not interested in that. I don't think they care, but it's the point about making the investigation. That goes to the reason. That's just an illustration. They're not interested in that. I think it has put into the spec.
Council, are we all ready? Court rise, if you're able to.
We needn't trouble you, Mr. Harry. We're going to dismiss this appeal for reasons to be given later in writing.
Well, look, can I just raise one very quick point?
Yes.
A very quick point. Can I just invite you to look at paragraph 69 of the judgment, which is at page 57 of the court manual. I just wanted to make one point just to bear in mind. Because I know you've read the whole of the judgment, my learned friend took you to later passages, but the judge did say at para 69 whether the giving of such an undertaking is the starting point or not, it is right in my judgment that they should give it in the circumstances of this case. So he then goes on to discuss Sinaloa and the other authorities. But I just draw that to your attention because that is his position as at paragraph 69 before he goes on to consider those authorities. I'm grateful.
Thank you very much.
Rise.